This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the Forms 34A uploaded on the public portal and the physical Forms 34A delivered to bombers that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the Forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them. Yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an deponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code, that swearing to falsehoods is a criminal offense, and 2, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit, and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Camargo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Camargo accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value. The KIMS kit relating to Songonyo Primary School, which bore the same serial number with another, was admitted by IMBC as an inadvertent manufacturer's error. We are also satisfied that the two kits and other identifying features that were markedly different, including the timestamps and polling code, and therefore nothing turns on this anomaly. Therefore, to the question whether there was a difference between Forms 34A uploaded on the IMBC public portal and those received at the National Tallying Center and those issued to the candidates' agents at the polling station, we have found none. Issue number 4, on whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachiriba, Rongai and Pokot South constituencies, and electoral ones in Yaki West in North Imenti constituency and Koanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners, and especially in petition number 5 of 2022. It is common knowledge that IMBC postponed elections for various seats during the general elections of 9th August 2022 due to mix-up of ballot papers in the above-named electoral units. It is the combined case of the first and second petitioners that, in terms of Articles 136, 2A, 177(1), and 181, as read with Article 1 of the Constitution, the chairperson of IMBC had no jurisdiction to postpone elections in those areas. That Section 55B of the Elections Act is inconsistent with the Constitution and therefore void to the extent that it purports to donate to IMBC power to postpone elections in the constituency, county, or ward, contrary to the Constitution, and the postponement undermined the conduct of free, fair, credible elections by depriving the voters an opportunity to vote for all the candidates on the dates stipulated by the Constitution. The petitioners further contend that the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question, which was prejudicial to him. Both the first and third petitioners also believe that elections were deliberately postponed in Kakamega and Mombasa counties. It was arranged that these areas are considered to be first petitioner strongholds, and as such, the postponement of elections worked to his disadvantage and handed that benefit to the second respondent.